this off, sort of.
Yeah, you can do that. You may want to turn off when you're not speaking, just so copies for you. All right, good evening, everyone. I'm going to open the meeting at 7:01 p.m. I'm just going to give a quick opening statement regarding tonight's agenda. My name is Maureen Lepak, and I'm the chair of the Board of Health in Brookfield. Local boards of health in Massachusetts are required by state statutes and regulations to perform many important and crucial duties relative to the protection of public health, the control of disease, the promotion of sanitary living conditions, and the protection of the environment from damage and pollution. Tonight's meeting is being held to conduct a public hearing on two proposed regulations intended to protect the public health and environment by ensuring the sanitary and safe operation of marijuana businesses and the sale of marijuana, and to regulate marijuana businesses to prevent nuisance within Brookfield. The purpose of these regulations are to protect the public health and welfare by ensuring local oversight and inspection of marijuana establishments and the sale of marijuana and cannabidiol by the Board of Health, consistent with the authority given to municipalities under Mass General Law. Therefore, in furtherance of its mission to protect, promote, and preserve the health and well-being of all Brookfield residents, and pursuant to the authority granted to it by General Law, Chapter 111, Section 31, the Brookfield Board of Health is seeking to enact these regulations. While boards of health are not required to hold public hearings before enacting regulations, we feel that it is important to hear from residents before doing so. That said, we may or may not be able to incorporate every suggestion into the documents. I also want to add that the documents have been recently reviewed by our town council, and several comments and edits were provided as part of that review to me today. Once the hearing is over, the board will resume its review and go over the documents, incorporating town council's considerations, and then may take any action relative to adopting the regulations. The board may also choose to continue the review and/or hearing, depending on what we discussed tonight. So next, I just want to go over some housekeeping rules before we open the hearing. I know some folks have joined that may have to grab the sign-in sheet from them. Go ahead. So I am the chair. I'll be calling upon members of the public who have signed in and indicated that they wish to testify before the board. When your name is called, come to the microphone to provide your testimony. If you would like to testify and have not signed in or indicated that you wish to testify, please sign in at the sign-in table. Each member of the public will be given a chance to speak once. We usually do 2 minutes. I think it's safe to say we could do 3 minutes if you'd like. Testimony must be directed to me, the board chair. Each testifier will state their name, address, and any pertinent affiliation before speaking. Testimony should be limited to the topic of the proposed regulations. As a public hearing, rude, disrespectful speech will not be tolerated. That includes remarks attacking the character of an individual or including statements that someone has an agenda or ulterior motives. Applauding, cheering, booing, or other expressions of approval or disapproval are not permitted. Failure to comply with these rules may result in you being escorted out of the hearing by an officer. Board members will refrain from engaging in dialogue with those in the audience. The purpose of tonight's hearing is to hear from you, the public. Testimony will be taken up to, I think given the number of people here, we are able to get through everyone, and we shouldn't need to continue it. But if we had a lot of people here, we'd probably have to cut it off by 8. If there are still members of the public who wish to provide testimony after everyone has spoken, raise your, I'll do a quick ask of the audience just to see. You can give me your hand, because I know a few people put maybe down, and I want to make sure you have a chance. After that, the hearing will close, and then the board will continue with its review, as I stated previously. I don't know if you want to bring me, okay, you're going to bring that up. I'll wait for you. Everybody? Okay. All right. Do I hear a motion to open the public hearing?
I'll make a motion to open the public hearing at
7:06. Second?
I'll second that.
And all in favor?
Aye.
Aye. All right. So the public hearing is now in session. The first name on the list is Steve Carmen. Please come up. Thank you.
Yep. Good evening, Maureen. I provided a statement to the board prior to this meeting. I'm going to be referencing that for my statement here. It has been my wish that the Select Board, the Planning Board, and the Board of Health collaborate when making decisions that affect the public health, especially when introducing businesses to our town. These businesses can affect the well-being of residents, and marijuana facilities are certainly one such business that could affect the well-being of residents. And while I believe that all three boards have good intentions when serving our community, I believe collaboration between your respective roles will lead to a better outcome for our town. And I believe it makes sense that the Board of Health has an important say in these policies because you directly pertain to policies that protect and promote public health. I think it's important to look at where we stand in terms of current zoning bylaws and business agreements for marijuana, because the work done by the Planning Board and the Select Board is pertinent to the decision here too. And I think they have made some decisions that should be weighed in these policies. So as far as zoning bylaws go, Brookfield's zoning bylaws for marijuana establishments were most recently amended in June 2023. The biggest change there was marijuana cultivation facilities are now allowed in rural residential areas, and there were no changes to the zoning bylaws to add additional safeguards to residents. So by this change, marijuana businesses can now be closer to homes, but residents are not granted additional safeguards to protect them from such nuisance. I think safeguards are even more important now for that reason. And there are two nuisances in particular that I believe are worth addressing. The ones that come to my mind are odor and wastewater management. And the Select Board has initiated host community agreements with one cannabis company thus far, and their host community agreement does address both odor and wastewater and waste management. And in my statement that I provided to you, I provided those sections of the host community agreement. I think it is worth assessing what they wrote there, because rather than define things for an individual marijuana business, I think it would be best to have a level playing field and take these reasonable wordings and apply them across the board. And so as far as odor is concerned, there are many reports of odor concerns, and I believe that residents would be negatively impacted if there were insufficient odor mitigation requirements. Same thing for wastewater management. That's a great concern too, because marijuana, any water use that comes into contact with marijuana is considered wastewater. It cannot be dumped on site. It must be trucked off site. And we are all on private septic in Brookfield, which makes it more challenging to manage such things. So I think the nature of our town does require that. There was one additional thing that I think was worth addressing as far as nuisance, and that's light pollution. I provided some statements on that. And right now, once again, the host community agreement that the Select Board has signed does contain obligations for lighting to avoid light pollution. I have two questions for you. From my understanding, both zoning bylaws and proposed Board of Health regulations are appropriate means for defining rules and policies for all marijuana businesses in our town. I've seen towns use both approaches. So what advantages do zoning bylaws versus regulations have? And my second question is, For light pollution, would you consider adding that to your regulation? And if not, I would consider promoting a zoning bylaw change to address that. Thank you.
Thank you. We'll take that under consideration. Okay. All right, next on the list, Karen Reynolds, are you? Okay. We have a no. How about Jessica Smith? You're all set? Okay. No. Joanna Cox? Hi.
Hi, good evening. I just also wanted to second everything that Steve Cartman said. I also had looked at this and I thought that the lighting, soil, and wastewater was not included in the draft proposal. I feel like that a lot of towns have still having problems with marijuana grow facilities, even though that a lot of provisions are in place. The odor is still something that the town people still complain about, even though that the owners of the property or the facilities try to mitigate that. So I think that maybe there should be some stronger language in regarding the odor issue, that because the people that are going to be closest to this will probably be the most affected. So everything that Steve Carmen said, and maybe just add a little bit more and more stringent language.
Thank you.
Thank you.
Take that under consideration. Okay, so. I can't. Your husband, Mr. Cox, I couldn't make out your first name.
Yes, good evening, ma'am. I guess my biggest question.
Can you just say your
Oh,
ad-
my
I'm
name is
sorry.
Wardwell Cox,
Wardwell
and I live on Molasses Hill.
Yeah, go ahead.
Thank you. My question, and I'm not sure if it falls under your purview, but this is going to be a rather large facility, and it falls outside of a hydrant district. So I know that we have mainly a call fire department. How do they intend to bring in the water for a suppression system for a building that, and correct me if I'm wrong, I don't remember if it was 40,000 or 60,000 square feet. But how do we address the fact that, how are we going to sprinkle that building and have enough water to suppress fire if it's there, with a fire department that they do a great job, but they're also call and they have limited equipment and resources. Plus, to put out a fire in that kind of building, we're going to be trucking in a significant amount of water. How do we deal with that, and where does it go? Because it's right on the border of a wetland. So those are my main questions. Thank you for your time.
Thank you.
Thank you.
Okay. Joe Gingras? You're all set? Okay. How about Tara Fitzgerald? You're all set. Alex Olson?
Hi, I'm Alex Olson. I don't have any prepared statement, and I read these today, so bear with me for a second. So on the regulation of marijuana establishment to prevent nuisance, the one comment I had was the fines for enforcement seem rather low compared to what I would expect for this kind of injunction. And the other thing that I wanted to mention was similar to what Steve had said on the wastewater permit. You know, there's a mention of required a hazard waste permit will be filed with the Board of Health annually. I would be maybe add some wordage into what those requirements are, and then if required, a wastewater permit and reports are filed with Massachusetts Department of Environmental Protection. Again, what limits for wastewater discharge, testing, and permitting through the state probably should be mentioned. The other thing that I would want to bring up is for manufacturing sites, what are the insurance requirements for facilities that contain solvents or other chemicals that are harmful to the environment. Should be mentioned within the nuisance regulation. But I do appreciate you guys putting this together. I think it's very important for our community. Thank you.
Thank you for your comments. We'll take those under consideration. Kevin Damon?
Nothing to add at this point.
Okay, thank you. Robin Ingman? Okay. And then we have Dave Holcraft.
I just got a question on, as a board, are you going to, a lot of people have the concerns tonight. What is your procedure on entering them into your hard work of your draft here? And thank you for doing the draft. I see it's quite a bit of work, but are you going to enter any of the concerns here tonight into this draft? Then you're going to have another draft done?
We'll be discussing following the hearing and may be able to answer your question then
Okay, thanks.
in general. Okay. All right. Is there anyone else in present that wants to provide testimony tonight?
Can I add one more thing?
Sure. I think even maybe your questions got cut off, so go ahead. Come on up.
Okay. This was not part of my testimony, but I was reviewing the regulation to ensure the sanitary and safe operation of marijuana establishments and the sale of adult use marijuana and cannabidiol. And the aspect that I was curious about was, does this affect any type of rights for individuals? So I believe in the state of Massachusetts you can grow 6 plants as an individual, 12 per household, and you can gift up to an ounce of marijuana to individuals. There are some references in here that prohibit gifting of marijuana and things of that nature, and I would just like to know if this regulation has any impact on individuals, not businesses, but individuals.
All right, we'll address that. Anyone else? Go ahead, Karen.
Hi, Karen Reynolds. My question is actually about the enforcement section of it, where it says that it would be Board of Health designees in the Brookfield Police Department. What if there's a no trespass order issued? How will that be handled as far as being able to get on the property to inspect? And my other question is, if the permit, if a person has a business has a permit and then they decide to put the business up for sale, is it automatically transferred to, say, a large corporation wanted to come in after everything is in and buy up the whole thing? Is it automatically transferred, or do they have to go through the whole process and reapply?
Okay. All right, thank you. All right, going once. Oh, go ahead, Joanna. Yep.
John Cox, Molasses Hill Road. I just had a quick question under the Section 3, the offensive or noisome marijuana establishments, numbers 9 and 10. I was just wondering how it was going to be emit odor interferes with personal, reasonable, peaceful enjoyment of their property. How would that be quantified, and how would you complain or approach the boards in such a manner, and what types of descriptions that you would need for somebody to relay that to you? Endangers personal or real property. What does that entail? What are the definitions for those types of things? What
Okay.
information would you be looking for? Thank you.
Thank you. All right. I don't see anyone else looking to speak tonight, so do I hear a motion to close the public hearing?
I'll make that motion to close the public hearing at, I think it says 7:20.
7:20.
I'll second that.
All in favor?
Aye.
Aye. Okay, so our next item on the agenda is for the board discussion on the proposed regulations. So here, the board will be discussing the regulations, but the public comment is now closed. I'll try to address questions that came up, and we may not be able to address everything, but we'll do our best. And then also we have documents to review further, so bear with us. All right. One thing I wanted to state. One thing I wanted to state: a board of health can require a permit, set a fee, or require substantive performance standards as part of a regulation. Boards may regulate by describing in a regulation all possible conditions under which an activity can be conducted without substantial injury to the public health, without having to include a requirement for a permit. In some instances, it would be difficult, if not impossible, to specify in a regulation conditions under which a person could conduct an activity without Board of Health review. I think that's the case here. The board may instead require a permit, which is how we wrote this regulation, whereby the board makes a decision based upon evidence presented on a case-by-case basis, and that is a finding from the courts, Butler versus Town of East Bridgewater. It dates back all the way to 1953, but it still stands. And so when we do talk about inserting various details into the document, be aware that not everything can necessarily fit neatly and be so prescriptive, where we don't have some instances where we have to leave it to the discretion of the board or the discretion of the health agent. In most cases, we consult with state authorities such as the DEP and Mass Public Health, but we always go through a health agent who's trained. And I can tell you that our health agent, our current agents that are in the coalition, do deal with marijuana businesses already, so they're familiar with the operations and the issues that go hand in hand and some of that. So when they are looking into, say, a nuisance issue or complaint, they do have experience and training on dealing with that. So that's just one comment I had. And then a couple of the questions that came up, I think, one question came up about when there's zoning bylaws and Board of Health regulations, like what's the advantage one over the other? And feel free to speak up to, but zoning is the planning board is tasked with creating the zoning and enforcing the reviews of plans related to zoning. The only area that the Board of Health has to do with actual zoning is for noisome trade. And noisome trades are businesses that have the potential to cause injury or harm, to estates. The language that has been, referenced in the documents. We have to cite by law those types of businesses as well. The only thing is the zone. We can't put a business in a place that's already restricted by zoning. But we could create additional restrictions on certain businesses that are technically allowed by zoning based on that business's potential to be a threat to public health and the environment. So, that's kind of like the difference there in terms of what our different purviews are. We want to respect the zoning bylaws in town. I know the planning board did a good job, trying to put together a fair and balanced bylaw in that respect. The Board of Health just has a different job. This comes up a lot too in discussions, the CCC's regulating, why do we need the Board of Health? Well, the CCC has a job and they do oversee the sale of marijuana and the licensing of. But when it comes down to dealing with nuisance created, that's where they say defer to the local Board of Health, because the state law has given that authority to local boards of health. So, we work with the Department of Public Health and also the DEP when it's dealing with different air quality. So indoor air quality is under the purview of Mass Public Health. Outdoor air quality is under the purview of Department of Environmental Protection. Soil, DEP, things like that. So we work with those individuals that help us to kind of navigate through, because as you know, we're three just citizens of Brookfield that have been elected to perform, duties that are quite numerous and can be complex at times. So we do lean in on experts whenever we can. We hire engineers when we need to. We hire, the appropriate experts to help us through that process, and that's pretty typical. We haven't had local regulations in Brookfield, so to date, dealing with a nuisance in general has just deferred to the state law. The state law, basically says it's in the opinion of the board. That can be quite subjective, and many people are kind of taken aback by that. And it certainly took me aback a little bit when, putting that into perspective overall. The Supreme Court has always ruled in favor of the boards of health's decisions in that regard. So, I think it's important that we are all cognizant of, these laws that have been on the books for many decades, and the language that's used. It's quite powerful for a board of health. They do, and when you think about what happened in 2020 with lockdowns and everything, there was quite a bit of conditions placed on the public in order to protect the public health. So we as a board, we want to be fair in town. We want to be considerate of the residents. We certainly want to protect your homes, your safety. We want to be fair to businesses too, and make sure that we have a regulation in place that's going to be consistent with what they might see across the state, but also, meeting the needs for Brookfield. And so I think, yes, zoning has its place, but so does the Board of Health. And they're not necessarily, it can be confusing at times, the swim lanes, even with the select board and different places, everybody's got the whole goal to help, protect the resources and the residents. It's just that the Board of Health has a specific role that's been deemed through Mass General Law under the authority, and that's why you see boards of health making these types of regulations in addition to others that you may see out there. A lot of towns have regulations for various aspects of Board of Health. This is just one, and there may be others. I know someone brought up light pollution. It's been on my mind, but I think it's not just marijuana businesses that could be subject to light pollution. So I think, in my opinion, to discuss with the board is that, the document may not cover specific to light pollution, because we may want to introduce regulation specific to that or defer to the state. The DEP has a lot of standards around light pollution, idling, things of that nature. So sometimes it's best to handle those things in that general sense, and that might be why you might not see them in a specific document like this that's just covering marijuana businesses. We don't want to imply that only marijuana businesses have to follow this and that. We want to make sure it's fair across the board, because all businesses have the potential to have light pollution or wastewater issues and things of that nature. So that's just where I think most are coming from based on the wording. The wording that you see from the original document came from the Massachusetts Association of Health Boards template on this. It was written a few years ago, so the laws keep changing and evolving. And then a lot of towns have implemented these over the years. We sent this to review for KP Law. They kind of brought the document up to date for us. Both documents are now shorter in their version, and I brought those tonight so that we could review them on this board. I think it's probably, I went through all of the comments and I thought they were all very fair comments and appropriate comments. Some sentences deleted, some sentences changed, and others just making notes for things of us to be aware of based on the current climate. So it was very good to get that review, and I appreciate their effort. Another question that came up, I think, was talking about fire hazards and suppression. I think that more falls to the fire department. There's usually a fire permit that has to be issued, but we are cognizant of the fact that water in town is not supplied through town water out in the residential areas. It's a well water. They have to have a plan in place in general for how they're going to manage water, because these plants just take a ton of water to begin with, and the wastewater is also something that we have to think about. But as far as
Would
the
it also be conservation, or?
well, yeah, they would
Yeah.
have their role
Right.
under Wetlands Protection Act, but the so it gets. It sounds, very complex. It kind of is. When you're building a house or anything else, you got to go to the building inspector. You got to go to the fire department. You have to go, build wiring, electrical and plumbing, and there's all the various places that permits need to be issued. For us, we're not going to overstep what the fire chief, would deem appropriate for. Whether or not the town can control that. That's also something the select board should consider. They sign an HCA. They should be taking those kinds of things into consideration. But that said, if we saw an environment where we thought there was a dangerous situation, we'd certainly defer and, make contact with the state, talk it out, and find out, if there's a problem there, and then bring that to the attention of the respective departments. We wouldn't take over their role, but we would try to, like you said before, Mr. Carmen, that we want to collaborate. We certainly want to work, cohesively with the various boards and also the fire chief, police chief, and whatnot, to make sure that the operations there are as, of the type that we would want to expect, and what the CC will expect. So, another question, I believe, came up about the adding language for the wastewater. I'm hesitant myself to try to add additional specificity to the document, because the DEP in places where there's a wetlands or where there's going to be a wastewater issue, or in just anything that's affecting groundwater, the DEP is going to be involved in giving out a permit as well. And so they're going to have a say in that. They're also going to review these documents, and provide us their feedback. We can still enact them in the meantime, but we do send them off to the DEP to review. And if they come back and they say, you should add or change language, we can always amend a regulation accordingly to do that. The other comment that came up, I think, Mr. Holcraft, you asked if, your concerns, what was the procedure for of bringing in comments. I think most of what I've heard tonight is been thought out. I don't think, there's nothing really kind of out there that's not, we haven't heard. We've seen a lot of you have come to us at a prior Board of Health meeting and raised some of these concerns. And so, and we got wonderful notes from you. And so we have been thinking about these things. And, as we go through the documents in a couple of minutes, we may decide we want to add language. We may decide not to add language at this time, but be mindful that not adding a specific sentence about, something like light pollution or wastewater doesn't mean that that's suddenly not a issue or will not be dealt with, and to prevent a nuisance. The Board of Health can do quite a bit to ensure that there's no nuisance, and we would certainly lean in on state agencies to help us with that task. And then, does it affect individuals? No, this regulation is for marijuana establishments. It's not to interfere with an individual's rights for what's allowed by law. If an individual is going outside of what the law is, that would be dealt with like any other nuisance complaint coming in. But this particular regulation is meant to guide businesses that want to operate in town, not individuals. So just to make that clarification. And then I think a couple last questions that came in. There is no transfer of any permit, so a new, this goes with a food establishment or liquor store, or someone selling tobacco, any business that requires a permit from the Board of Health. Those permits generally expire at the end of each calendar year and have to be renewed annually. And if they're sold, they cannot just transfer the permit. So we recently, for example, had a mobile park that was purchased. That mobile park now has to go through the permit process again, even though it's during the same year as their previous permit. They're not transferable. So, and the other, and how, emission of odor, how do we quantify that? That's a topic that comes up. I went to the Mass Association of Health Boards conference earlier in the spring. They talk about this is more of an issue. You can measure sound with a device. Smell is not as specific, but basically, the agent would basically stand at the property line, and if they can detect the odor, and if the odor is of a level that is noisome, noisome is not just that there's an odor. It has to have like this putrid kind of element to it that's going to irritate someone, be enough to irritate someone's ability to enjoy their property. It has to be enough, or having an asthma issue, things of that nature. So like businesses with idling, all of those other types of things that we deal with. There are sometimes it's a little trickier to determine what that is, but if we do receive a lot of complaints about an odor, we send we would send the agent out to evaluate that, and if they detect odor, there may be order to correct given to make sure that the business is doing everything possible to contain that odor and not make that prolonged. I know that it's not always, like what we've seen happen in the history of, marijuana being legalized in town, in the state, that there are a lot of companies that have had odor issues. Even indoor cultivation companies have had that, having a difficult time being able to filter that. But I do know that there are some newer technologies that are helping with that. And, at least, from my perspective, the other board members can chime in, but, I would do everything possible to make sure that when you're at your property line, that you're not being inundated by any odor from any business that's operating anywhere in town. I mean, I know some people brought up a specific applicant, because we do have an applicant right now with the select board and with the HCA, but this regulation is not geared to that person, and it's geared to anyone that was doing that business. And so we're going to look at it in that viewpoint, and go from there. So with that, any additional comments that either of you want to add before we kind of just get into the document?
I think there was a question on enforcement. Is someone allowed to put a no trespass order on a Board of Health?
Oh, well, if we look at the document text, there is text in there that they have to agree to allowing the agent on the property. There's constitutional rights for, people coming on property. If they deny a health agent permission to enter the property, the health agent can get a warrant and enter the property. We wouldn't go there just unannounced. Generally, it's not. We try not to do that. When it's like food businesses and stuff, we try to, pop in, when we can, the agents kind of try to not have too much advance warning, but at the same time, you need to make sure you have permission to enter. But if they're not giving permission to enter and they're being, they're not wanting to comply with oversight and being, rejecting any kind of oversight, well, that's obviously going to raise an issue that would go into more of an administrative warrant, and then an enforcement action would happen at that point. But it's very rare. Most businesses are very, open. It would not be in their interest to, try to take out trespassing orders against the agent or something like that. That's probably not going to end well, because they're just going to go get a warrant, and then somebody's going to go in there, whether it's her or somebody from the state. So that would be my take on that. So yeah, we did get feedback from, I want to make sure I don't lose my place here. Hold on 1 second. I think, let's look at the sanitary and safe operation document. And you should have, if you don't have one, I can share. We had the original document that we had posted when we scheduled the hearing. It was a 10-page document. KP Law reviewed the document, had quite a few comments and edits to make, and I have these here. So if either of you can't read, you've got the oh, you got it printed differently. Okay, so you good. So as I went through it myself, I mean, the gist I got was most of the comments were not super, out there. I think in general they agreed with most of the document, but what they did was bring it up to date, because some regulations have changed. There's things now that the CCC oversees. There's there was, I think, some language around hemp, that was outdated. And then there was just other pieces that were probably more verbose. For instance, the statement in purpose and authority, they were able to reduce that to 2 short, paragraphs that were sort of general and didn't rely on us quoting every single act in the state, because the rationale, these things tend to change, and we don't want to have to change our regulations every time there's a change in the state regulations. So I thought that was a good idea. I also strongly advise us to, consider, KP Law, because they do work on a lot of these and have, a lot of experience. So, so that whole section on page 1, where all the bullets that got, on their version, that is just 2 short paragraphs, basically reiterating what I said in the opening statement. They, under the definitions, they added, they just clarified some of the definitions and spelled out a couple of them a little bit more. Basically, I think there was some reference to RMDs, so now they're considered, medical marijuana treatment centers, and so they just changed the verbiage to be more in line with the current regulatory atmosphere, and then they added a customer definition, so they wanted to say that a customer is a consumer or patient who is legally on the premises of a marijuana establishment, CMO or MTC, to purchase marijuana products, or marijuana accessories, and so that made sense. And I found it interesting. They did ask what the fee for the permit was, like, and suggested incorporating it into the regulation. However, we discussed this at our prior meeting, that we have a fee schedule document that they didn't have in front of them. But as we make the fee for the permitting, you know, we'll probably defer to what Leicester Coalition already sees as fees, because that makes sense. And then keep that in our regular schedule, so that in the event that that changes, that we don't have to amend the regulation every time we may have to amend a fee. Not that it happens very often, but, you know, it's more expensive today to do inspections than it was 10 years ago, so, that was I think the only comment I didn't incorporate, just because I think that everyone's better served having it. The fees will be listed in the application document, and they'll be listed online with our schedule. So I think we can refer to that.
Right.
They also added a definition for licensed premises, saying that the term's used elsewhere, so they wanted to say that all land and buildings associated with the operation of marijuana establishment, MTC, were CMO, so that was added. And they also expanded the definition of marijuana accessories to include all accessory types. I think that I'm just trying to give the audience a gist of what was changed. They added definitions for a marijuana retailer and a medical marijuana treatment center, and the minimum legal sales age. They moved up in the order of the document. And then they deleted the registered marijuana dispensary definition, since it's now called Medical Marijuana Treatment Center, and they gave a definition for that. Under Section C, the marijuana sales to persons under the minimum legal sales age are prohibited. They just expanded statements number 1 to incorporate marijuana accessories, and they removed items number 3 and 4 because delivery is now allowed, and then number 4 was kind of a duplication of number 1, so they just incorporated accessories into that statement, and so that just brings it up to date. So the marijuana operating permit, they added a little language around, you know, being prepared to show proof of a current and valid license from the CCC if requested. Generally, they're going to get that after they get all the rest of the town licensing in place. So it's, I think there was originally language that made it seem like they needed to have the CCC permit in hand before they got the Board of Health permitting. One of the changes was to not make that requirement, but to request it, and upon renewal of a permit, that they would have to provide evidence of that permit. There's just some wordsmithing. On they added that all permits, unless otherwise established, expire annually on December 31st, and that marijuana operating permits shall be posted in a conspicuous place at the licensed premises. So just adding, kind of moving some text around so that it has a better flow. Talk about hearings. And this was on page 7, number 11. They added language that hearings will be held pursuant to Section M of the regulation, and if a violation was enforced by non-criminal disposition, any appeals shall be taken pursuant to Section 5 of the bylaws of the Town of Franklin and General Law, Chapter 40, Section 21D. So they just added better language. They just clarified the language around the fact that marijuana retailers are prohibited from selling tobacco and alcohol. And then they had the question if the statement, if required, a hazardous waste permit is to be filed with the Board of Health annually. I believe the hazardous waste permits are done by the DEP, so we added language for the DEP, as they are for a wastewater permit. And I think for out-of-package sales, you know, they noted that white labeling of products is allowed under CCC, so the language is edited a little to ensure that that language is not meaning that we're prohibiting white packaging, white labeling of products, but just trying to avoid the breaking up of packaged items from the store. And then under the Section K, the CBD, hemp products and sales, the first number was out of date because, you know, the MDAR regulates the cultivation and production of hemp, and a lot of these products are widely available. You can go to CVS and get a lot of these products, so we don't want to prohibit that. And so under that, it just kind of takes that section and reduces it to what is part of that, which is that no person shall sell hemp or CBD products to a person under the minimum legal age, and that no person shall sell CBD or hemp-infused food products, dietary supplements, or products that make medical or therapeutic claims unless already approved by the FDA. And then just kind of not limiting it to, but the Epidiolex, you know, these medications that are approved from the FDA, but so they just added language so that it's not limited to that one, which was good. And then they removed some language that really doesn't quite fit, that was from either the template or a prior town. There was like, we're not going to, it's the building commissioner that enforces the authority of zoning or ZEO, so it wouldn't be us. So we wouldn't be able to just say, oh, you're not, you know, complying with the zoning bylaw, like you can't have a permit. We have to go through the proper enforcement there. And then they deleted the language around the security plan in the Brookfield Police Department because they're already required to do that and share those plans, and I think that, yeah, I agree with them that that's kind of beyond our scope. So like removing that makes sense because that is, CCC requires a security plan, as does the police. So there's no need for the Board of Health to add additional burden there. And also, the Board of Health may require distribution of additional educational materials in marijuana establishments. This is probably old text. CCC regulations already require certain specific types of educational materials be provided. So imposing a requirement just seems to be, inconsistent with the state regulation. I don't see the need to do that unless you guys disagree. And then they removed the Brookfield Board of Health in consultation of the Brookfield Police Department and other Brookfield officials, departments that may set limitations on the hours. That's really out of our scope as well. These should be, I didn't notice that one either. That came from the template. And in my opinion, that is a zoning, that would be covered under their zoning permit.
And what is this next one?
The election of one remedy by the Board of Health shall not preclude enforcement through any other lawful means. It's just, it just means that it's not the only, the town can, do enforcement, or the state,
Okay.
or the Board of Health can seek other remedies to ensure that any problems with compliance are dealt with. So that was added by KP Law. And then the last page, this is the longer document, so thank you for bearing with us. They did delete the, if permissible by local bylaws, any fines or fees collected under this regulation shall be used for the administration enforcement, blah, blah. There's like a section there, and they deleted that section. They wanted to also recommend leaving the frequency of inspections to the board's discretion, because inspections can become onerous for staff, or they may want to, they may need to do more frequently depending on the situation. And then they just kind of, I'm just trying to see how they deleted this. Yeah, so the fines, fees collected, that they're actually, I think there's rules around how they can be used. So they took out that statement. I think that was the template's probably 6 or 7 years old, and that was an older language. So they removed that. So I think that we just, agree with that, because they know. And they added in the, additional language around the public hearing, which is an important element too, that, if we are going to suspend or revoke a permit, we provide notice, but also we have to hold a public hearing. So, and give them an opportunity to address the board and all that typical language that we would see. So that was good that they caught that. And then they added one section right at the end: notwithstanding the hearing requirements set forth above, any Board of Health agent may summarily suspend any permit based on the existence of an imminent threat to public health, safety, and welfare. Any operating permit holder receiving a summary suspension shall immediately cease and desist from the permitted business. The Board of Health will conduct a public hearing of which the operating permit holder is given 7 days written notice. After such hearing, the board may affirm, reverse, or modify the summary suspension order. So that grants the agent, the ability to swiftly deal with, any imminent threats to public health. And I think, typically people are surprised to see how quickly, agent can shut down a business or enforce an order to correct or go to court, but it happens at time. It really depends. It's a case by case. They're trained in understanding, what they would deem as an imminent threat versus, something that they may give 30 days to correct, something like that. So that was that document, and so there is a clean version of this document in front of you as well. It changed the length of the document down to 9 pages, so it was nice to see it get a little shorter. So on that document, is there anything based on what we've heard tonight and based on the feedback that we would want to alter, or?
It was brought up that the fee, maybe on the low side. I don't know. We
The
didn't
fees
talk
for the
about
second
that.
offense and third offense. Well, that's a typical, I think the law allows us to fine up to $1,000 per day, but that seems pretty prohibitive. I think, where are you on that page? Hold on.
10.
Okay, so
11.
let me look at the clean document where they have the first offense 100, second offense 200, third and subsequent offenses 300. Could be kind of low, especially if a very large business. However, some businesses are quite small, and this is kind of encompassing all. I think if we had a situation in which an offense was going on, and they had like a third offense and a fourth offense, and we were issuing fines and having to deal with that, I think then comes into play whether we want to meet and revoke a permit altogether. I think I don't look at it as like a way to try to collect as much money as possible from a business, but a way to instill that this is a violation and there's a fine associated, and if you ignore the fine, you'll be fined again. And you continue to ignore that fine, then we go to court, or we hold a public hearing, revoke, and then there's an appeal process, of course. They're not clean, when you run into those kinds of situations. That's really why when you're reviewing an application that you vet, the business thoroughly, and assess their ability and willingness to be compliant with the rules and regulations. If we see a business that's not looking to play well in the sandbox, so to speak, then I think that's something you take in consideration in the initial review. If they are granted a permit and then all of a sudden they do an about face and they're not complying, then there's enforcement actions taken. And being that there are multiple agencies always involved, it's not just the Board of Health. In a nutshell, in isolation, we certainly would notify other agencies like the Department of Public Health or the DEP or the CCC about that, so that those agencies are aware. I don't foresee any reason why a applicant would go through all the work of opening a business only to get themselves shut down for being, non-compliant. I think that would be foolish, but
Okay.
do you have any other thoughts about this particular document?
No?
Okay. All right. So let's put that one to the side for the moment and go to the next, which is the regulation of marijuana establishments to prevent nuisance. Again, this one's a little easier and started off as a 5-page document, and after the KP Law made edits, it's down to 4 pages, so nice and simple, which is,
I don't have that.
that's the one you don't have, this one, right?
Yes.
And so let me read off and then I'll kind of let you have my copy. Basically, much less changed here, but the statement and purpose of authority, they again narrowed down that lengthy multi-bulleted section with just 2 paragraphs that highlight, the authority and the purpose more concisely. They took out a couple of definitions. They took out a weighted sound level. They said, in their opinion, the definition is not necessary as the term is not used elsewhere in these regulations. And so I did a search, and they were right. It's probably a hangover from a prior version of the document. They also, again, just those same edits about noting that RMDs are now referred to as medical marijuana treatment centers. So they made those kinds of administrative adjustments. And they also took marijuana infused product out of the definition because it's not necessary, the term's not used elsewhere. So that made sense. They took out the pure tone definition because it's also not used in the document. I think when we copied over sections of the MAHB template from the original that we started from, that's where some of these hangovers came from. Okay. They added a little bit of text here and there to, strengthen the, when they create a noise when measured at the property boundary of the receiving land in excess of 10 decibels above ambient noise level or otherwise in violation of 310 CMR, and then they put the word or so that it's, make sure that it could be any one of these circumstances. And then they they strengthened up number 6, emit an odor which is discernible by a reasonable person of normal sensitivity. So that actually, I did talk to someone from DEP, and that is kind of the standard that they use. It's relatively subjective, but it's basically a reasonable person, normal sensitivities, anyone, smelling that and being kind of overwhelmed by that, then that would be the standard that they apply. There's no real way of measuring smell otherwise, but they just leave that as a definition, and that's what the state uses. So they did add that to strengthen it up. And then on page 4, they just moved the fine language down further for flow purposes, and they added language, the marijuana establishment shall have 7 days or such other time as the Board of Health deems reasonable when there's an order. So that just kind of gives us more flexibility. They added also some one statement above the fine information that says if non-criminal disposition is elected, then the non-criminal fine for each such violation, if not otherwise specified, shall be. And then they put that language. And so I think that is also a key difference, that those fines are non-criminal fines, but if they were, being taken up to court on a criminal, then, yeah, the fines can be quite large in that regard. We wouldn't want to see that. And so I think that's mostly, where did we go, 5.5, and then, and the only thing they also added to these is just that, when we sign, if we vote to adopt these regulations, we sign, they become effective, but we also have to do a publication of a summary of the regulation in a newspaper of general circulation. And so once that takes place is actually when the official effect takes place. So it's not just us signing, it's us also publishing a summary of the regulation in the paper. And so that just makes that clarification. Okay, so that's that. Does either of you have any other comments?
I think everything's been pretty much talked about.
So, if we have no further changes on these documents as they stand, I do think they've covered a lot of the comments that came in tonight. I think, there are some reasons why certain language may not be present, in a specific to marijuana document that probably is best in a separate document or is already dealt with by the state in their own regulations that we can, defer to. So based on what I heard tonight, I don't have any concerns that we'd be not able to protect or, prevent nuisance and to allow the safe operation of a marijuana establishment. I think what we would have to do if we enact these, we have to immediately start looking at application package, and that's something that our health agent and the new director can help us with at the coalition, because those exist already for other businesses that they already inspect and review regularly. And then that would be then we'd set up the fee and then put the fee in the fee schedule, but those things would just kind of be subsequent at a subsequent meeting to just confirm, but
Don't we have to submit before that and get feedback from DEP and review that, or no?
we can sign, publish, and then send it to DEP.
Okay.
It's a courtesy review. We do need to send it to them, and I wouldn't want, we won't have anybody in town in the next month anyway,
okay.
operating, so, I think, we send it to them and get their feedback, and then everything kind of falls into place, so.
Okay.
So on that note, if there's no changes to be made, this is the new document with the changes from the KP Law review. Both documents, the sanitary and safe operation and the prevent nuisance. Do I hear a motion, or would anyone like to make a motion that we adopt and enact these regulations as written?
Do you want to make the motion?
I'd like to make a motion that we sign and adopt these regulations
Can we say enact? Okay.
as written.
Just to be clear on the, Kim, you're making a motion that we vote, I'll say vote rather than sign, vote to enact the regulations as written? Does
Yes.
that sound good?
Yes.
Okay, do I hear a second?
I'll second.
Okay, seconded. Any further discussion? Okay. All in favor?
Aye.
Aye. Okay, so we each have to sign. I'll hand it to you to sign. I'll sign this one. And the effective date, we'll add the effective date when it's published in the paper. And sign that one. And then that one.
Are these all extra copies right there?
Yeah, basically.
Okay.
All right. Do I hear a motion to adjourn?
I will make a motion to adjourn at 8:15.
I'll second that.
All in favor?